Thank you. We- We're here in 1CACV 19-0049 Ashkenazi versus Baldino. Each side will have 20 minutes to present their argument. Appellant, you may reserve any time that you want for rebuttal, but you'll have to keep track of that time yourself or click at the podium for that purpose. We are recording the argument. So when you begin your argument, please identify yourself and your client so that we can keep everything straight on the recording. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the law and the facts of this case. So when you begin your argument, start out with what you want us to know. Counsel, you may begin.
Good morning, Your Honors. May it please the Court, my name is Mark Sifferman. I represent the appellants in 1CA CV 19-0050, which is consolidated with 1CA CV 19-0049. Ms. Barnes represents the appellants in that case, the Baldino appellants. I represent the appellants Eva Spur Reporter, Baseline of Val Vista Limited Partnership, and Litchfield Road Associates Limited Partnership. We've agreed to split our time up. I'm going to address the delay damage issue, and Ms. Barnes is going to address the anticipatory breach and mitigation damages issue. We will keep track of our time, and we hope to reserve some time at the end for rebuttal. In looking at the issue, whether the wording of ARS section 44-1201A applies to this case, one should consider, does that statute 10% rate, is a 10% rate a fair and honest determination of what the appellee's loss was? And more,
Is that the counsel? Is that the standard contract damage? Fair and, or is it to place the party in the position they would have been at the contract?
my point more was that
Which is
it is to place them, it is to compensate the loss that they suffered. So to put them in the position that they would have been. So it's the actual damage suffered by the plaintiffs, by the appellees. And the problem in this case is what has happened is 10% has been deemed to be conclusively by statute the measure of the plaintiff's loss.
Well, Counsel, I have a factual question about this because I'm at a loss to know why that statute came up. I mean, what was the genesis of picking, or I must be picking, of relying on the statute rather than what would normally happen where the party would try to prove damages by evidence?
Your Honor, I believe I can answer your question. When the appellees cross-moved for summary judgment on their breach of contract claim, they asserted as their loss, they argued that their loss was measured by 10% statutory rate of 44-1201A.
Did they explain why they picked that?
They said that, I can't tell you why they did. It was simpler. The important thing is their complaint, as we said in our brief, stated what the proper measure of damage was, which was the actual loss to the plaintiffs of the lost investment rate they could have gotten had they gotten the money, had they gotten the Greenberg Trout money earlier. So it would be measured by what they would have gotten as their investment rate.
Did the plaintiffs have an expert? Have they offered any evidence of that by the time your clients got to the summary judgment stage?
No, Your Honor. No expert was designated, and the fair inference is going to that statute was easier for the plaintiffs because they could say, well, 44-1201A is the statutory rate, and therefore you apply that.
Statutory rate for what?
Well, I would say that the way it was argued by the plaintiffs below and reached by the judges, it is always the rate that's applied to everything before judgment. And that's not what the statute says, and it's clearly not how the Supreme Court in Meltzer defined it. The Supreme Court in Meltzer said the statute, 44-1201A, has to be interpreted narrowly, and it's a loan indebtedness obligation.
So let's say we were to send you back down to the court. Do you have evidence to put on to prove? Let's say it's not this sort of untethered statutory number, but that you have to prove it, that there was damage. Do you have such evidence since you haven't named an expert witness?
Well, we're the defendants, Your Honor. So the plaintiffs never had an expert. So the issue never came up. What we argued before the trial court was you have to show actual loss, and relying on the statute doesn't work. Even the legislature recognizes the loss investment rate can be a different percentage rate. It can be Federal Reserve Prime plus 1. There's other statutes the legislature has adopted for the loss based upon another rate. So the answer to your question, Your Honor, even though we cross-moved for summary judgment.
So I guess I'll ask it this way. Was there an expert witness deadline that has passed such that if it were to go back down, that would have saved it?
Your Honor, I can't answer that question specifically. I don't believe that anybody would be precluded on remand for developing exactly what the actual loss to these plaintiffs was. When Judge Broman decided we're going to use 44-1201A, that's it. We're going to use that statutory 10%. It kind of went by the wayside. We argued that there were other rates that can be used, and we argued in our briefs we cite cases, including the Arizona case, which as you look at the actual rate that was lost or incurred.
And so you argue to the trial judge, we don't owe the plaintiff anything yet. And that's why that rate doesn't apply. Or that's why the statute doesn't apply, because we never owed anything until the judgment against us came out.
Well, our argument is that what we are accused of doing is causing a loss by delaying
Right.
the third party pay.
But that wasn't determined until the court ruled.
Correct. And so it was not, the loss is not a debtedness or obligation within the meaning of the
Right.
statute.
Did you make that argument?
Oh, yes, Your Honor.
That's all right. You can keep going. I think that
no,
was Judge
well,
Howell's question.
Specifically in our responsive statement of facts to the plaintiff's summary judgment motion, which is item on record 205 through 208, in paragraphs 57 through 59, we specifically said you can't use the statutory rate. It doesn't apply. There's a supplemental brief at 226 and a reply at 230 where we specifically argued that the statute simply does, the terms and words used in the statute simply don't apply in this instance.
Can I ask about that? And given some of the other cases that are out there that deal with prejudgment interest in a case where a third party has undermined the ability to get some money, there's at least been a judgment entered against them for a dollar amount, and then the prejudgment interest was based on that dollar. Do you understand what I'm saying?
Yes, when we're dealing with, let me rephrase and make sure I understand. When you're talking about prejudgment interest, it is interest on a principal amount. The judgment has determined what that principal amount
The
is.
principal amount is established, not just established, but it's established as a judgment in that case.
Correct, and then you have prejudgment interest
On that.
on that principal.
Is there any case out there where the statute has been used, as it was here, to establish interest on an amount that was never reduced to a judgment?
No, Your Honor. Don't believe there's any case that goes there. The cases we cited talk about the determination of what the customary rate is, or the market rate, or the actual rate paid by the plaintiff. So they don't talk about applying a statutory rate in this kind of situation.
Your argument only, for lack of a better word, infects the damage part of the trial judge's holding. So really only a remand to recalculate damages based on that argument. The judge doesn't have to re-tackle the breach.
Well, Your Honor, except we cross-moved for summary judgment on the basis that the plaintiffs had failed to prove the element of loss from the breach of contract. Therefore, we asked for summary judgment.
Okay, so but even that, as an element understood, a prima facie case, breach of contract, the point is still, what is the loss for this, what has been deemed breach?
Yes, Your Honor.
Okay.
To the extent the arguments for anticipatory breach and mitigation affect.
And if we were to remand this, would you object to the case going forward because it's too late now, or would you be fine in litigating?
Well, we would like you to say that the court erred in not granting our motion for summary judgment. But if we remand it, it's start over on that issue.
Okay. Thank you, counsel.
Judge, do you have a question for me?
Yeah, counsel, please forgive me, and the time is short, so I'll ask my question up front. If this court found in a previous opinion that the attorneys had actual authority to bind the group, whether your clients were there or not, what difference does that make to the attorneys having actual authority to bind the group? And I'm asking because I think that gets to the heart of the anticipatory breach issue.
Well, I think, Your Honor, respectfully, it's not at the heart of it in this context, because the enforceability of the settlement agreement was what was at issue in the underlying case against GT, and the later appeal where this court ultimately, in fact, after the summary judgment finding in the case we're in today, it was a year later, determined that there was binding authority to enter into the settlement. What's at issue here doesn't involve that. Now, the majority rule provisions of the intra-client agreement and engagement agreement were assessed in terms of making that ultimate determination of the enforceability of that settlement agreement. However, what's at issue here today does not pertain to that. What's at issue is whether or not plaintiffs, the Ashkenazi plaintiffs, did something to breach materially the intra-client and or engagement agreements, which we would contend are one thing, but we can address that. They did something such that they can't not pursue damages for delay for our clients, the Baldinos and Spur Reporters, challenge to that settlement agreement. So it is a different thing.
Well,
it seems like it's connected, but it's really not. It is a separate issue.
Then what is that thing?
I'm sorry, what is that thing?
Yeah. What is the thing that the Ashkenazi plaintiffs do that violated the agreement?
What they did are what we alleged in the record. There was a meeting that occurred prior to the mediation, so that was on April 12th, there was a meeting, and there has been already a determination that there was a dispute between the two factions. And there was animosity, there were issues, and Mr. Baldino in his underlying papers pointed that out in his statement of facts, that created conflict. They then sent follow-up emails to the attorneys saying, we don't want Mr. Baldino at the mediation, and here's why.
But he said he wasn't going.
So, two things.
What was the breach?
The breach is a combination of those actions.
But there's got to be some provision that those actions breach.
So Baldino wasn't allowed to go. That was one thing, even though he didn't intend it. What's next?
He was convinced, the attorneys were convinced to tell him not to go. Yes, there was a fact pointed to where he said to them, allegedly, that he was not going to go because of what happened at the mediation, or I'm sorry, at the pre-meeting. But it's their actions at the pre-meeting, their follow-up emails that convinced the attorneys to say that.
What was the damage for that? Let's move on. Let's say that was a breach. What was the damage?
The damage?
How would things have ended differently, given that counsel had actual authority as determined by this court in an earlier case?
Well, that's the problem, is that speculation to determine what would have happened. The damage is that they didn't have the opportunity, and because Ms. Porter was rejected from attending once she got there, and Mr. Baldino was going to rely on her participation as his other member of the steering committee, they did not get to participate in that mediation. While the attorneys could buy...
Did the contract require them to participate? Or provide that they must be present?
The contract in those express terms did not say that. However, it said...
But it did expressly, as we found, give the attorneys the authority to act.
It gave the attorneys authorities to act. But what our position is that there's a factual dispute about whether or not there could have been a different outcome had they been allowed to participate, which our argument is the steering committee provision.
But they weren't required to.
Say that, I'm sorry, Your Honor.
They didn't have to be allowed to participate.
Our argument is that they did, based on the express intent of entering those agreements, that it be based on their ability to be the steering committee. The steering committee was to have day-to-day operation of the litigation in conjunction with Brown and Ross, the attorneys. And if they had been allowed to continue in that day-to-day operation of the litigation by attending the mediation, which their position would be that that's their anticipated benefit of the agreement. Why would they handle and be involved in the day-to-day operation of litigation throughout, only to then say, okay, go do whatever you're going to do at the mediation? Had they been given an opportunity at the pre-meeting, which they weren't, and or at the mediation, which they weren't, to express their reasons for why a settlement in the dollar amount that was being proposed should not be accepted,
So
we don't know what would have happened.
We have to accept the final result, right? We have actual authority. We have this court saying there was actual authority. That can't be challenged. What you're saying is that your client had maybe some persuasive abilities and would have been able to move hearts and minds in that room, such that when the attorney was ready to exercise that actual authority, it would have been a different outcome.
It could have been.
And so that's not we're supposed to speculate as to the persuasive argument. If you're in the room, it would have come out differently because why you had what points. How do we assess that?
Well, we're assessing it based on whether or not that amounted to an anticipatory breach, which precludes them from pursuing delayed damages for challenging the outcome there. That's what the difference is. And what we have argued is there were factual issues that a jury should have been able to hear and determine on whether or not that intervention, that those actions of interfering with their ability to be there and have a voice, then relieves them from having to owe some dollar amount later for having challenged the outcome at the settlement. I'm sorry, at the mediation.
Well, counsel, I still haven't heard you identify a provision in the agreement that required them to be at the meeting or forms the basis of the breach. It seems like we're talking outside the agreement.
Well, two things, and I see that I'm out of time, and we were trying to
Please.
reserve time, but I've been answering questions if we can able to set a couple of minutes aside still potentially for rebuttal. But the answer is, one, there is a steering committee provision in the engagement agreement which provides that Baldino and Sperber Porter, can be involved in the day-to-day operation of the litigation and be the voice of the group. Our position is that in and of itself says they should be able to participate in that mediation because that is a part and parcel of the day-to-day operation of the litigation. In fact, it is the crux of it because it's going to potentially determine the outcome of that litigation. But also, the breach of the covenant of good faith and fair dealing can amount to a material breach as well. So that's why I'm saying the overall actions that were taken, that were in the record for the trial judge, amounts to a material breach insofar as a summary judgment ruling, and it should have gone to the jury to make that determination.
Thank you, counsel.
Thank you, Your Honor.
I appreciate your argument, counsel. And if I might ask, I'm not trying to control your argument, but could you begin with the breach issue?
Certainly, Your Honor. I was planning on doing that.
Thank you.
I appreciate that. And may it please the court, I'm David Weatherwax of Sherman and Howard here on behalf of the plaintiffs who have been simply trying to get their money now for well over 6 years, resulting from the breach caused by the defendants. With me here today is Mr. Matthew Hesketh, who's also a member of Sherman and Howard, and Mr. Jake Rapp, who is a law clerk with our firm. With respect to the alleged breach, Your Honor, you got it right. Contractually, these defendants had zero right to, with respect to any settlement authority whatsoever, and had zero right with respect to being at the mediation. They were part of the day-to-day decision-making with the lawyers up to the point where the plaintiffs as a group granted their lawyers settlement authority at the mediation. That was a done deal. So the lawyers had the settlement authority. They went to the mediation. They actually did better than what was allowed. So that's number one. Number two, as Your Honors noted, Mr. Baldino decided well before, we plaintiffs did nothing. He decided he just wasn't going to the mediation. And Ms. Sperber, she showed up unannounced. Nobody from the plaintiffs group was there. Nobody from the plaintiffs group told her she couldn't participate. But again, contractually, she had no right to do it. So when you combine that with the fact that it was the lawyers who supposedly told her not to participate in the mediation, that's not the plaintiffs, but more importantly, the defendants in this case sued their lawyers and said in the arbitration proceeding, because it was subject to mandatory arbitration, that was one of the breaches, if you will, and as a result of that, the settlement wasn't enforceable. So they litigated that issue, and the arbitrator said, hold on, they did nothing wrong. You lose, And for that reason, among others, they're collaterally estopped from bringing this argument here. So unless you have questions, Your Honor, let me move on. With respect to with respect to this argument about actual proof of damages, let me say this before I get into the substance of that argument. First, I want to advise the court, and I think you know from our papers and from Judge Brodman's own ruling, they failed to make that argument timely below. Period. They failed to make it, and Judge Brodman ruled that they failed to make it, and as specifically said in response to a question about expert testimony, the argument that plaintiffs needed expert testimony to prove their interest damages is rejected. It's also a new argument not presented to the court at the time the court ruled on the motion for summary judgment.
Well, counsel, what about in their response to the Ashkenazi plaintiff's motion for summary judgment, when they do raise whether or not ARS section 44-1201A is where you look for damages?
What they argued, Your Honor, was that subsection B applies, not A. So that's what they argued. They said subsection B applies, not subsection A, because this is not an obligation or indebtedness of our clients. And that's simply, they're wrong on that. And I believe that Judge Brodman got it right, and I'll speak to that in a minute. So they didn't bring up this proof of actual damages.
Well, counsel, on the issue of waiver, if the statute as a matter of law is inapplicable, and I realize that that's partly what's the issue here, but if it is inapplicable, why would we apply waiver? Because then we'd be condoning an erroneous application of a statute. So doesn't waiver in this circumstance go by the wayside and we have to resolve the actual legal issue?
So first of all, Your Honor, I believe that the legal issue, and I believe our papers set this out, and I'll argue more in response to their reply. Under the law, 10% interest was the right amount of damage on a liquidated claim. The plaintiffs had the right to seek damages in a number of ways, one of which was to simply say, all we want is our prejudgment interest on this liquidated claim. There is no doubt that this claim was liquidated, zero.
Well, counsel, I beg to differ. It seems there's a great deal. I agree that the amount is not in dispute, but the question is who owns it. The plaintiffs may have delayed your clients from getting that money, and that may have caused your clients damage, but they didn't owe that money. So that's why I'm having difficulty as a legal matter applying the statute.
And Your Honor, with all due respect, they did owe the money, and here's how. There's no doubt that they weren't, quote, holding the money, and it was that the money was being held by Greenberg. However, as soon as they breached the contract, which prohibited Greenberg from paying the plaintiffs their share of the money, as soon as that happened, upon that breach, the defendants became liable to, indebted to, and obligated to the plaintiffs for their consequential damages resulting from the breach of contract.
And you don't need a judgment? We don't need courts to determine that?
Absolutely not, Your Honor. And first of all, it has been determined now 3 or 4 times.
No. But wait, so this statute, what you're saying, doesn't require any judgment. It's just sort of somebody saying, yeah, that was against the contract, begin the whatever clock there is.
That's right, and because it was a breach of contract. And Your Honor, the case law in Arizona is absolutely clear, and it says that that prejudgment interest on a liquidated claim is a matter of right in an action on tort, on a contract or in a tort.
As your very damages, and nothing more and nothing less?
That's right. So, Your Honor,
we're not talking about there's other damages here, right? You're saying that's the damage.
that we are saying that that's the damage that the plaintiffs had the right to pursue and chose to pursue. That's it. They could have gone for a higher damage if they chose to. And what the defendants are arguing is that, and it's an argument they didn't make below, but their argument is every single plaintiff in this group had to show the court what they would have done with the money had Greenberg paid it in January of 2013 rather than in August of 2018. That's what they're requiring, and that's not the law. They argued, I think they first mentioned, is it fair? And I think Your Honor correctly stated that's not the issue, whether or not it's fair or not. And indeed, I would like to I think the court may know this, but the defendants provided no admissible evidence here or below for their argument that the 10% rate exceeds the market rates of interest or an average rate of return.
But okay, let's talk about your liquidated argument. What has to be liquidated?
The number. I'm sorry, Your Honor. I didn't mean to
The
cut you off.
amount that Greenberg had agreed to pay as part of the settlement, or the damage of this delay from this date to this date? And how would that be liquidated?
Because, Your Honor, there was a certain amount of money that Greenberg agreed to pay. Period.
Right. Okay.
So
We'll
that's
take that.
liquidated. That's liquidated. The second
But
step.
that's not the damage
No,
you're asking for.
No, let me go on. The second step is that by breaching the agreement, Greenberg failed to pay that whole amount. Our damage, the plaintiff's damage, is limited to what their net share of that amount would be, $7 million approximately. So because Greenberg didn't pay, the plaintiffs had a liquidated claim of $7 million. And
Against who?
against the defendants because they caused, that's the damage from the breach.
So your damages are really in this breach of contract $7 million?
Your Honor, and we made that clear below. We were seeking, our damages were $7 million, if you will, plus the delay damages, the interest, which accrues in every contract case as a result of the delay. So that's what we were seeking. The reason we didn't ultimately get that, frankly, is because everybody expected, because Judge Anderson had ruled, the arbitrator had ruled, ultimately this court had ruled that the contracts were enforceable, and as soon as that happened, after the Supreme Court refused review, denied review, they said, okay, we give, Greenberg, you can pay. So,
But counsel, the money that your clients were entitled to receive from Greenberg Trowbridge were in any sense damages that the plaintiffs owed. The alleged act that they did that caused injury was delaying the payment. So they were never on the hook for the underlying amount. They were only liable for the damages that came with delaying your clients from getting the Greenberg settlement.
that's not correct, Your Honor, with all due respect. If Greenberg, as a result of their actions, had said, look, we're done, you didn't comply with your obligations under the agreement, we're done, agreement's off, settlement's off. My clients, the plaintiffs, have damages because Greenberg would have paid the $7 million, but for that. No, Your Honor, but that's why there are, it is, but that's why there are damages. So until Greenberg paid, and Greenberg only paid as a result of the plaintiff's efforts to mitigate their damages, once Greenberg paid, the amount of damage went from $10 million, resulting from the breach of contract, which was the $7 million plus accrued interest, to just $3 million, or $3.9 million. So the judge here got it right. The judgment it was for what was left, which was the delay damages, because the principal had been paid.
So your argument hinges on whether or not we find that there's a liquidated damage amount that they are responsible for, or at one time were, if we were to put this in slow motion and take a snapshot, and that made it a prejudgment case, and so because that's liquidated, you can then look at the 10% and apply that as the delay damage.
Your Honor, yes, and here's why. I mean, this is not like any other breach of contract
You're not
case.
trying to tether directly your damage to the 10%. You understand it's untethered and without any connection other than it's a number, and you are damaged a number.
It's not a number, Your Honor. Under the law in Arizona and in many other states,
Right. Okay. Well,
delay damages can be compensated by interest at the statutory rate. That's the law.
Well, delay damages what are the damages that what? What is the measure of a damage? I guess in a breach of contract.
Here it is. The breach of the agreement caused $7 million not to be paid to the plaintiffs. From the date of the breach until the money was actually paid, we are entitled to two things. Number one, the full amount of damage, the $7 million, which the defendants agree is liquidated. And number two, all interest accrued on that amount up through the date of the payment. So had Greenberg not paid, our damages would have been $10 million because they would have caused Greenberg not to pay.
And it's irrelevant that they did.
No, it's the
say
relevance. The relevance is that it reduced the amount of the judgment that we would have received. Let's assume.
Well, and it allowed you this 10% kicker without regard to actual evidence of whether or not the value of money that you would have received during that time, investing it in A, B, or C, would have yielded a certain result. There's nothing to do with that. You're just picking a number from a statute that the legislature adopted in connection with something altogether different.
In connection with obligations or indebtedness. And it's a tort claim, Your Honor. Let's take a tort claim. Let's just take that claim. And let's say it was a liquidated amount. But it's not decided until judgment is entered. That's why you have the prejudgment interest. That's why our Supreme Court has said you are entitled as a matter of right to prejudgment interest even on tort claims. This is a contract claim. You are entitled to prejudgment interest as a measure of damages, as part of your damages, on contractual, on damages resulting from a breach of contract. Your Honor, it's not a difficult.
Who said, other than the contract, that there was money owing before a judgment was entered on whatever claims were asserted by your client?
That's like any other contract claim. But in this particular case, the contract said Greenberg will pay X amount. The intra-client agreement amongst the parties, amongst the plaintiffs and the defendants, said this is how we are going to share the amount that Greenberg pays. When Baldino and Sperber breached the contract, we then sued them, not for their share, but just for what the share would have been had Greenberg paid. That's the damage that resulted from the breach of contract.
And you're saying you could have also gone the other route, which is try to prove what actual damage is to the penny, the value of money, as we said.
We could have.
But you didn't. Instead, you went to this interpretation of this prejudgment claim on on an amount that was paid.
Well, on an amount at that point that was not paid, and Your Honor, it's not a,
At one point was not paid.
it is a statutory right in Arizona, just as it is in many other states.
You have a case that has that exact same sort of application where you had someone pay off the underlying indebtedness, but the plaintiff wielded the statute as the central mechanism for their delay damage claim?
I don't have a case at my fingertips, but let me suggest it this way, Your Honor. Let's assume...
Well, you might have cited that.
The court, let's assume that we got a judgment. The court granted summary judgment, and the court said, your damages are liquidated. You are now entitled to $7 million plus all of the delay damages, the accrued interest. We could have gotten a judgment for that. What happens under Arizona law, like most other places, is as soon as Greenberg pays, they get a credit for that amount. And that's what would have happened. That's essentially what happened here. As soon as Greenberg paid, they got a credit for that amount. So, Your Honor, this case is no different than any other breach of contract case. They breached the contract. As a result of that breach, damages were incurred. Every plaintiff could have come in and said, I would have invested in Microsoft. I would have invested this. That's speculative, and but that's what they would have said. And frankly, I just watched an argument here where I believe it was Judge Swan grilled people on this. It might have been you, Your Honor, but grilled people on this. Are you saying that they have to prove that they would have invested all of their money in Microsoft, or they would have bought a house and the house would have appreciated by 3 or 4 times? That's one way of doing it, and that's an expensive way of doing it, and because of the law, they're not required to do it. They can simply say, you breached, this is what was the damage as a result of the breach. We are entitled to our statutory rate at 10% on that breach until it's paid.
Counsel, if we were to find that the court erred in applying the statute, then what?
Then you would be requiring, Your Honor, my clients to go back, and every single one of them, many are who are in ill health, to say, I would have invested in Microsoft. My broker told me to do it. I would have done it. And instead of 10%, I would have had a 30% rate of return. And keep in mind...
Well, but I understand your equitable argument. I'm asking procedurally what you would do if we ruled the circuit was inapplicable.
Well, first, Your Honor, what we would do, candidly, is we would take it up, okay? Because
of course.
I believe it is applicable, and I believe that Your Honors would have gotten it wrong, with all due respect.
Of course.
But short of that, if it were remanded and we had to go back and prove up damages, depending on how Your Honors ruled, we would have no alternative but to I guess, get everybody to testify that this is what they would have done with the money had it been paid in January of 2013. And with all due respect, that's not required by the law, and that's why we have the 10% interest statute. So I just want...
The pitfall here, just to make clear, is you're not talking about damage in the traditional sense. When you say, well, we're looking for the statute, you're saying this is a form of compensation provided by the legislature. And don't get confused when we talk about damages, because we didn't pursue that route. It would have been more expensive. Instead, we had this route, which is, I guess, damages, prejudgment interest. But we at no time were we using that as a mechanism to measure the value of money.
We were using that as our right under Arizona law to value the delay damages that were caused when the $7 million wasn't paid. And we have that right as a matter of law, Your Honor. And that's what we were doing. There are damages that result from their breach. The damages were the failure to pay $7 million that my clients haven't got now for over 6 years. The court correctly decided below that number's liquidated because you held it up, and at any time you could have said, you could have let Greenberg pay that money at any time, but you didn't. So you are responsible under the statute for interest that continues to accrue. If I might, Your Honor, their argument below wasn't what they're making here. It just wasn't. What they argued below was that the statutory rate of prime plus 1, subsection B applies. That's what they argued, and they relied on Metzler, and for the reasons we set out, Metzler simply doesn't apply. Metzler was the court applied the lower rate in Metzler because that was a sanction. The rule requires prejudgment interest. That was a sanction.
Please come up. Your timer is off. Can you come up?
Okay, unless there are no other questions, then my time.
Thank you, counsel. And because we ran over, we'll give you 2 minutes.
Thank you, Your Honor. I would point the court to page 10 of our reply brief. There we point out that the plaintiffs never claimed as damage the amount that Greenberg Trout was paying. They didn't claim it in their complaint. They didn't claim it in their summary judgment. We cited to you on page 10 those parts of the record where they did not claim it. All they claimed was the loss, the delay in not have the loss caused by the delay in not receiving that money. And the record cited also contains their disclosure statements, which they don't say or even imply that the defendants would be liable for the Greenberg Trout money. So let me turn to the record. What you were told about was the judge's ruling on the motion for new trial. The judge, though, in its record item 231 on page 6, in ruling on granting the plaintiff's cross motion for summary judgment and denying ours, says, defendants argue the individual members of the Ashkenazi plaintiffs have not established their individual damage. Obviously, Judge Brodman knew that we were arguing they had to prove it. And to make it very clear, you take a look at item 209, which is the response to their motion at page 15, we say, plaintiffs were required to prove each of the 44 co-plaintiffs' individual damages. And this final comment about prime plus 1 under 44-1201B. Our argument was, at most, that is what it should be. But our argument is it has to be actual loss proven by the plaintiffs. Thank you.
Counsel, so are you arguing that each plaintiff has to present evidence of what they would have done with money, or can that be done collectively that, that each of the plaintiffs could have earned this amount, that the time value of the money without regard to what each individual would have done?
If I can answer that by stating what I think the law is in damages, that the fact of the loss has to be proven specifically, but the amount is open to some debate. So how you prove it, the cases that we cited, there's a number of different ways of proving the loss. And it's not necessarily that you have to prove it what each plaintiff would have done with their investment. Thank you.
Thank you, counsel. We appreciate your very good arguments today. We'll take this matter under advisement and issue a decision in due course, and we stand adjourned. Thank you.